So we're doing third terms now. Yes, last week the media dropped a story that they considered an absolute bombshell. Donald Trump says he hasn't ruled out running for a third term. Now, it seems like we've been through this before on this channel, and I didn't expect to have to relitigate this question quite so soon. So everyone, listen up. The Constitution does not give President Trump the power to serve a third term. The 22nd Amendment says he cannot do it. And while I agree it's important to take most of Trump's threats seriously, America is in immediate and serious danger because of the challenge that Trump poses to the rule of law. So let's try and keep our eyes on the ball because he's threatening to burn America's justice system to the ground right now. But that being said, today let's summarize the law on the 22nd Amendment, its history, and the reasons why we need to stop focusing on emergencies that are 4 years in the future, and then never talk about this ever again. Now, to understand why Trump can't run for a third term, we need to look at why presidents are term limited. When the framers debated the Constitution, Alexander Hamilton and James Madison had the truly terrible idea that the president should be nominated by Congress to serve for life. This was rejected for the obvious reason. The US had declared independence from Great Britain because they did not want to be ruled by a monarch. Hamilton's proposal would have created an elective monarchy similar to the Vatican. One person becomes the head honcho until they die. But instead, the framers came up with a compromise, an electoral college system where the president would have no term limits. The original Constitution, ratified in 1789, made the office of president a 4-year position. It also created an office of vice president, who would be the president's successor in the event the president could no longer serve. Now, the framers are lauded as political geniuses, but they had some really, truly stupid ideas. And apart from maybe slavery and selective suffrage, perhaps the dumbest idea that the framers had is that the person who finished second in the presidential election would win the vice presidency. But luckily, the Constitution was amended to fix that incredibly stupid oversight. More on that in a second. But in 1789, George Washington was unanimously elected president. He wound up serving 4 years and then winning a second term. He could have won again, but instead he decided to retire.
I'm stepping down, I'm not running for president.
And although Washington's retirement created a custom or a norm that presidents should retire after 2 terms, there was never a law stopping a president from serving a third term. And a few of them tried it. Ulysses S. Grant ran for a third term but lost the Republican primary to James Garfield. Grover Cleveland, the first president to win 2 non-consecutive terms, had a shot at a third when the Democratic Party nominated him again, but he declined. So Washington's decision to serve only 2 terms established a tradition that all presidents followed until the 20th century. Then cracks appeared. When Teddy Roosevelt lost the Republican nomination to William Howard Taft, he ran for a third term in 1912 under the Progressive Bull Moose Party. He split the Republican vote and Woodrow Wilson won. Wilson eventually sought a third term, but Democrats didn't nominate him. So you can see the pattern developing here. But in the 20th century, the norm of the 2-term president was not destined to hold. Then at the height of the Great Depression in 1933, with 24.9% of the nation's total workforce unemployed, along comes Franklin Delano Roosevelt. FDR's first 2 terms were focused on getting America through the Great Depression and rebuilding the country. Many of Roosevelt's reforms, like Social Security, were enormously popular. That's why voters easily gave Roosevelt a third term. Then during World War II, Roosevelt ran for a 4th term and won again. The only thing that could stop Roosevelt was death, and he died 83 days into his final 4th term. But Congress did not approve of President Roosevelt serving more than 2 terms. And in 1947, Republican majorities in the House and Senate passed a constitutional amendment stipulating that, quote, no person shall be elected to the office of president more than twice. After he passed, Harry Truman served 2 terms and he wanted a third, but the Democratic Party nominated someone else. Finally, in 1951, the states ratified the 22nd Amendment, which states, quote, no person shall be elected to the office of president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than once. The 22nd Amendment says a person can only be elected to president 2 times for a total of 8 years. A person can serve for a maximum of 10 years in the case of a president who ascended to the position as vice president, assuming that they ascended to the office of president roughly halfway through their predecessor's term. So that means it is theoretically possible for a president to serve more than 8 years in office under some very narrow circumstances. And the 22nd Amendment also addresses the scenario where a person serves less than 2 years of another president's term. This can happen if a president dies, resigns, or is impeached, and someone else steps in to fill their shoes. In this case, if the vice president serves more than 2 years of the term, they're officially only allowed to be elected once. And this was the situation for Vice President Gerald Ford, who became president after Richard Nixon resigned in 1973. Ford was only eligible to be elected once. So now let's address the core question, can Donald Trump run for a third term? Now, if you're going to violate the Constitution, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. By the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. President Trump served one term from 2017 to 2021. He is now, at the time of this video, 1/12 of his way through his second term, which started in 2025 and will probably end in 2029. I say probably because, anything can happen. Just ask the French.
We have almost 4 years to go, and that's a long time. But despite that, so many people are saying, you've got to run again.
But Trump is right. 4 years is a long time. So why does he think he has a right to a third term? Well, because some lawyers took a look at the text of the 22nd Amendment and they decided that they found a loophole. The 22nd Amendment says, quote, no person shall be elected to the office of president more than twice. These lawyers claim the word elected is ambiguous. And since the amendment doesn't say anything about serving a third term, then a person could serve more than 2 terms as long as they don't become the president through an election. Law professors Bruce Peabody and Grant Scott are the main proponents of this theory. They say, quote, notably, the text of the amendment restricts only re-election of an already twice elected president. The words themselves do not, 1, limit the amount of time, consecutively or cumulatively, a person may serve, or 2, prescribe such a person from reassuming the office of president by means other than election. But how would a person assume the presidency without being elected? Well, consider Gerald Ford. President Nixon appointed Ford as vice president after his original VP, Spiro Agnew, resigned. Then when Nixon resigned, Ford became the only person to serve as president without ever having been elected to the office of president or vice president.
The Constitution of the United States. So help me God. So help me God.
So think about how this could theoretically work in 2028. Let's say J.D. Vance runs as president and Kristi Noem is his vice president. And if they win the election, Noem could step down, Vance could appoint Trump as vice president, Vance and Trump could make a deal where Vance would resign and Trump could serve another term despite not being elected. There are other possible routes for a person to become president without appearing on the ballot. For example, Trump could become Speaker of the House, either by getting elected to Congress or getting the Republicans to give him the job, and then through resignations, deaths, or impeachments, wind up becoming president for a third term. President Vance could also share power with Vice President Trump, which is a plan they have apparently actually floated. And professors Peabody and Grant say the Constitution permits these gambits. But in order for a person to be eligible to hold the office of President of the United States, they must meet the following constitutional requirements. First, they must be a natural-born citizen of the United States, as outlined in Article 2, Section 1, Clause 5 of the U.S. Constitution. This means that they must have been born in the U.S. or be born abroad to a U.S. citizen parents under certain conditions. Second, they must be at least 35 years old at the time they assume office. And third, the person must have lived in the United States for at least 14 years. But there are additional qualifications and limitations set forth in the amendments. For example, Section 3 of the 14th Amendment bans insurrectionists from being president. It says, quote, no person shall hold any office, civil or military, under the United States or under any state who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So that means a person who has engaged in insurrection or rebellion against the United States is barred from holding public office. Now that's a whole can of worms that came up the summer before the election, and I'm not going to go back into it. But there is also the 12th Amendment ratified in 1803. It changed the process for selecting a vice president. Instead of the loser serving as the winner's VP, it allowed each party to nominate their team for president and vice president. The text says, no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Now, almost everyone agrees that the text of the 12th Amendment means that no person who is constitutionally ineligible to be president could serve as vice president, meaning that under the plain text of the amendments, Trump could never become the vice president. Now, turning back to the 22nd Amendment, which says that no person can be elected president more than twice, Peabody and Scott argue that the 12th Amendment does not come into play when interpreting the 22nd because the amendment doesn't use the word eligible. That's present only in Article 2 and the 12th Amendment. And there's also an argument about the true meaning of the word eligible. But law professor Eugene Volokh scrutinized the historical record and concluded that eligible already carries another meaning, and that meaning is elected. He states, quote, I realize that this is far from perfect evidence. It's 40 years later than the usage, but the earliest law dictionary that I could find that contained the term, Bouvier's 1843, defines eligibility as capacity to be elected. I've seen no evidence that, contrary to Bouvier's definition, a person would have been seen in the early 1800s as being eligible to an office when he was legally barred from being elected or appointed to it. And the only question related to whether he could automatically assume it under some succession statute. Moreover, Yale professor Akhil Amar pointed out that Peabody's interpretation of the words ignores the fact that, quote, the words eligible and electable spring from the same Latin root, and that standard dictionaries have long included electable as one of the standard definitions of eligible. See, for example, OED entry on eligible. Given these facts, it would seem that a two-term incumbent is ineligible to the presidency within the meaning of the 12th Amendment, precisely because he is made unelectable to that office by the 22nd, and is thus barred by the 12th from being elected to the vice presidency in the first place. And I think Volokh and Amar are correct. If the word eligible also means electable, then the 22nd Amendment would read, no person shall be eligible to hold the office of president more than twice. Now, one would think that would be enough to put the argument to bed, But it probably won't, and here's why. This is a classic example of lawyer brain. Now, normally I would mean that as a compliment, but not here. Lawyers are trained to examine every angle of a scenario, and we're taught to analyze the text for evidence to support our arguments. And if the text is not on our side, we look at the legislative history, and if history is not on our side, then we emphasize the facts, because lawyers don't like to give up easily. However, lawyer brain also has a dark side. Just because we can make a convoluted argument doesn't mean that we should make that argument, especially in a situation like this, where we know that the 22nd Amendment was meant to limit a president to 2 terms. So the drafters of the 22nd Amendment did not use the word eligible, but did they really intend to create a loophole that would allow someone to serve a 3rd term despite not being democratically elected? Absolutely not. The people who drafted the amendment were Republicans and conservative Democrats who were outraged that President Roosevelt was elected to a 3rd term in 1940. In 1940, the GOP nominee, Wendell Willkie, ran on the idea that FDR was trying to make himself a king.
And I would also like to debate the question of the assumption by this president in seeking a 3rd term of a greater public confidence than was accorded to our presidential giants, Washington, Jefferson, Jackson, Lincoln, Theodore Roosevelt, and Woodrow Wilson.
And if we could summon the ghost of Willkie right now, I promise you he would not say, yeah, we wanted to prevent the president from being elected to a 3rd term, but we were totally cool with this one weird trick ability to serve a 3rd term by other means. He absolutely would not say that. And Peabody and Grant say they understand that distinguishing between election and service may seem a matter of semantic parsing. It's creative semantic parsing that is contrary to the text and history of the 22nd Amendment. And as much as we would like to believe that the Constitution was written with a kind of biblical inerrancy, it wasn't. And constitutional amendments are incredibly important, but that doesn't mean that the people who drafted them were perfectly precise. The legislators who marked up the draft of the 22nd Amendment probably should have used the word eligible, but they certainly didn't intend to create an anti-democratic loophole. But the Constitution can be amended, and those people who think that President Trump should serve a 3rd term should advocate for the repeal of the 22nd Amendment. And even in the 1940s, there were people who didn't think that the amendment was necessary. They argued that the 22nd Amendment restricts the democratic choices of the electorate, and they said that if a president is popular and doing a great job, then voters should have the right to choose that person's leadership for as long as possible. But honestly, I don't know that any of this matters. These scenarios where multiple people resign so that Trump can take the presidency again seem incredibly far-fetched. That doesn't tend to happen, that people are elected to, the highest office in the land only to turn around and give it away to somebody else. Depending on what the Supreme Court does with all of Elon Musk's actions, maybe in 2029, Trump would be happy serving as shadow president and avoiding all of the 22nd Amendment rigmarole entirely. But fear not, apparently Donald Trump was distracted enough by the thought of becoming Pope that he said he was not interested in serving a 3rd term. Though who knows what the troll-in-chief is going to say next week. But it's particularly interesting to see how the media has covered this. When Trump originally clarified that he wasn't joking about serving a 3rd term, over 560 sources covered it, with about 20% coming from the right, 60% from the center, and 20% from the left. And when you examine the headlines, you start to see some very different frames emerge that shape how readers interpret and understand the events that are unfolding. From the right, the most common themes are to emphasize the existence of a so-called loophole, or that Trump believes he can do it. Then from the center, headlines typically lead with Trump's statement that he's not joking, while describing the Constitution as a barrier. And from the left, headlines also tend to lead with Trump's "I'm not joking" statement, but also characterize his ambitions as breaching the constitutional barrier, suggesting a warlike ethos. Now, the headlines that you read first have immense power to shape how you understand the news. And that's why I like to see the news from as many angles as I can, which I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering Legal Eaglets 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get the discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like this recent story of the former Wisconsin Supreme Court judge who abused his office to perpetuate the lie that Trump won the 2020 election and must now surrender his license to practice law. This story was virtually ignored by the right, with about a 50-50 distribution between the center and left sources. Now, this type of analysis helps explain why we often talk past each other and why some people seem hyper-focused on what seems like nonsense or fake news to other people. But this is all why Ground News is my favorite way to get the news. And as a Legal Eaglet, you can save 40% off their Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. By subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.